Hello, good afternoon. Just hit 12 o'clock in Ottawa, and we are ready to begin our webinar on hiring your first employee. This is the third in our series of webinars for small and growing businesses. And our first one looked at issues to consider when you are just starting out, and such as the pros and cons of various business structures. Our second one looked at issues that arise when you are starting to grow, such as shareholder agreements and taking out your commercial leases. Our third is looking at the complex area of employment law. And here to take us through everything you need to know when hiring and managing your first employee is Brent Craswell, employment lawyer here at Kelly Santini. Before I turn things over to him, just two quick things. The first is the slides are available from today's presentation in the control panel. You should be able to download them. If you have any issues, any difficulties, just drop me an email and I will happily send you a copy of them after today's broadcast. And second, if you have any questions during today's presentation, we'll reserve some time at the end to address some of those. And that's it from me. So I will now turn things over to Brent.
Thank you, Keith. So yeah, as Keith mentioned, this is meant to be a high-level primer when you're just starting out as an employer, hiring your first employees. And so the objectives of the presentation is just, as the slide says, to provide you with knowledge on how to protect your business from any liability for non-compliance with or bad employment law practices in general. It is a tricky area of law. Employees can sometimes be your biggest asset, but they're also a significant source of liability if not handled properly. So this is about putting in place things at an early venture, being proactive rather than reactive. And as I walk through different kind of scenarios, you'll see the financial benefit of being properly prepared at the outset and what that can offer. So on a high level, I'm going to go over four main topics. The first is the employment contract that you'll need when you're hiring employees. The second is workplace policies you'll want to have in place. Some of them are mandatory. They're required to have in place certain policies. Others are optional but can help you manage your workforce better. A third area which comes up a lot in my practice is employers having to deal with what their obligations are under the Human Rights Code, which is quite complicated. And the fourth is just a general high level of when you should be calling an employment lawyer or a lawyer in general, just to help you issue spot things and not make things better before they get worse. So starting with the first topic, the employment agreement, there's essential components to all of these agreements. It's basically meant to lay out all of the obligations and responsibilities of both parties to the employment relationship. So all of these things should be set out. And if there's an agreement between you and the employee, it should be in the employment agreement. You shouldn't be relying on any kind of handshake verbal agreements beforehand. Put it in writing so that everybody knows the score. So compensation, what is it just going to be a base salary? Is there going to be some kind of bonus compensation? Is that bonus discretionary? Are there commissions? What are the terms of the commissions? Any kind of stock options, things like that tend to come later, but all of that should be spelled out. And again, everyone should know exactly where they stand. Duties and responsibilities is another big one. Be as precise as you possibly can in describing what the employee is going to be doing, because you don't want to mutiny at a later stage when you're asking something that you fully intended to be part of this person's job, and it ends up being something that they didn't understand to be part of their job. Hours of work, again, how much are they going to be working? When are they expected to work in those hours? Some companies aren't 9 to 5, and you need to communicate at the outset if they're expected to work weekends or holidays or things of that nature. And as an employer, you're going to want to maintain as much operational control as you can. So maintain flexibility over when you can schedule employees and maintain flexibility in case your needs as an organization change. We typically recommend having them for an indefinite period of time versus a fixed period of time. Fixed term agreements can eliminate situations where you have to give notice of termination, but only in very narrow circumstances. And if you're intending to keep somebody on for over a year, there's really no benefit to having a term contract, in my view. It just creates more paperwork, and you have to remember when to update them, and you're just more likely creating situations where you're operating without an employment contract. So it's safer just to sign something at the outset for an indefinite term, and you'll know that it's in place until it's terminated or altered in some fashion. Again, the next is ability to change duties, responsibilities, and hours. Again, that's the flexibility notion. You'll want to maintain your right to alter the position as the needs of the business are changing, which is going to happen a lot, especially when you're just starting out. Something that I'll just highlight there is that you're not allowed to, as an employer, to completely change the duties such that it's an entirely different position, or drastically reduce hours so that the person's compensation is drastically decreased, simply because the employee could argue that they've been what's called constructively dismissed because their position has been so changed from the one that they originally signed up for that you've effectively terminated the employment arrangement. So that's just something to think about. You want to maintain the right to make smaller changes, but you can't make large, drastic changes. Vacation entitlement is another important one, not just the amount, but if it's unused, whether that carries forward and how much can be carried forward from year to year. It's a common source of something that comes up later in employment relationships where someone doesn't have the proper language in their contract and they've been carrying vacation forward for years, and you want to terminate them, but they have this massive entitlement to accrued but unused vacation. So again, best to limit that to the extent that you can. Sick leave entitlement, I could presently use some sick leave, as you can probably hear, but some employers offer it. It's not mandatory, but if you're going to offer it to your employees, then set it out in your employment contract. A big one, depending on the size of your business and the nature of your business, is protecting those business interests. So things like non-solicitation clauses, non-competition clauses, use of the confidential information that you're going to be providing the employees in order to do their job. All of this stuff, the employment agreement is a great place to set out, reserve your rights to the extent that's possible. Non-competitions and non-solicits could be a presentation on its own because they're very complex and courts don't really like them, but we do recommend using them in employment contracts to manage, to clearly express what you expect after an employment relationship has ended, and to ensure you avoid situations where you take an employee under your wing, you give them access to all your clients, and they resign and start a competing business right the next day. So that's a big thing to protect your company, especially when it's at a young stage. So the big thing for employment contracts, and the reason why they are worth the money that it costs to make them, is termination provisions. It's the most important provision. We'll chat about that a little bit later in a whole separate section. So in addition to the actual written contractual terms you have in an agreement, there are also implied terms in the contract by the legislation. So the Employment Standards Act sets minimums that can't be altered through contract. So things like minimum wage, you can't agree to pay somebody less than what minimum wage is. You can't really alter when overtime is due or how much vacation someone can have. There's all minimums set for things like that, or break times between shifts. And there's also set minimums and maximums on how much an employee can work in a given period. So unless you're providing a greater benefit than what's in the Employment Standards Act, all aspects of the ESA are implied to be as part of your contract of employment with any employee. And the ESA, part of the reason it's most often cited in employment litigation is because it sets the minimum amounts that you owe employees upon termination. So, but it does set minimums, but those aren't maximums, right? It's a minimum and not a cap. So it will say There's a chart in Section 57 of the Employment Standards Act which says exactly what you would owe as minimum notice in given situations, depending on how much service that employee has for you. And it maxes out at 8 weeks of notice for those who have worked for 8 years or more. So it can be still a pretty significant sum of money if you're terminating somebody without any cause, but it can be worse, and that's what's illustrated by this slide. So absent a strong contractual right to terminate in your contract with binding language, employees are entitled to a second layer of notice, which is called common law reasonable notice. And that's determined not based on any chart in any legislation, but by cases that have been decided previously based on similar employment factors. The factors as set out in the cases are things like age, length of service, their role with the company, their salary, the job market at the time, whether or not that employee was induced to come to work for you, to leave secure employment, come work for you. It can even include the time of year that someone was terminated in specific circumstances. So it's very fact specific, and there's no rule of thumb exactly for how much notice somebody's entitled on the common law side. So I have an example on the slide that if you have someone, who's older, who's doing an administrative assistant role with 20 years of service for the company, making around $50,000, case law suggests that this person would be entitled to 15 to 18 months of notice, right? So remember earlier I said you could probably terminate that person with just 8 weeks of notice if you have proper contractual language. If you don't have that language, you're looking at 15 to 18 months, so obviously a ton more. That's a massive liability to a business, and it makes managing your staff much more difficult. It gives you far less flexibility if you don't have employment contracts, because sometimes people just can't afford to terminate somebody who's been there for a long time, or who would garner an especially high amount of common law notice because of the factors that I talked about before. So employment contracts do have an upfront cost if they're drafted by lawyers, but they often pay for themselves the first time you actually need to terminate somebody with any significant length of service. And again, this just kind of goes, this sets the best case scenario that I just talked about limiting somebody regardless of their service to 8 weeks. The clause has to be worded in a specific fashion. There is a lot of litigation about upholding or trying to strike down termination provisions because they need to guarantee in all situations that the employee is going to receive at least the minimums owed to them under the Employment Standards Act. And that sounds easy to do, but there's been a pretty steady decade of litigation about whether or not certain provisions are binding, because they have to be binding in every imaginable situation. So it takes someone to think all the way around any possibility in order to draft a termination provision that's strong. And it's something that you can't just draft and forget too. It does require some, the law changes, so it does require some ongoing maintenance with your lawyer to determine if you still have a strong termination provision and whether you can still use the same termination provision going forward in every contract. And it's something you should, you can get a template from a lawyer, but then going forward, whether you need to update that should be addressed regularly with your lawyer. There are other factors which affect the enforceability of a contract. So obviously, if you're going through the exercise of having a contract prepared by a lawyer and presented to an employee, you're going to want to make sure that it's enforceable and you can rely on what is written in the contract. So the first thing is the timing when it's provided. You should provide it before anyone starts any work, and make sure you get it back signed before they actually start that work. And if there's any other documents referenced in that employment agreement that you also are relying on, so things like sometimes employers have employee handbooks which set out a bunch of different things that are too complicated to go over in an employment agreement, then you would attach that and provide it with them at the time that you're hiring the employee with the written offer. Excuse me. If, as you can see from the slide, an agreement is provided after the time that someone's actually provided services to the company, then you're going to need to provide them additional what's called consideration for them signing that contract. So that's a tenet of law that you need to show that one party has received something of value in order to establish that they've agreed to take on a responsibility or an obligation. So if you've started your employment relationship with no termination provision, for example, and then you introduce a contract after a week which has this very strong termination provision whereby the person would be waiving their entitlement to common law reasonable notice, you need to show that you gave them something additional of value in exchange for them agreeing to forego that right. So even though the person just started, you may have to pay them a signing bonus or some kind of raise in order to ensure that the contract that you have is going to hold up in court. Another way to do that to ensure the enforceability of the contract is to give them notice that their existing agreement, which is at that point unwritten because you haven't signed anything at the outset, is no longer binding, and you're going to be, as of the end of this notice period, bound by the terms of this new written contract. And that amount of notice that you require is dependent on the same factors I discussed before about the common law reasonable notice. So again, if you want to introduce a new contract for someone who's been there for a really long time, you're going to either need to give them a raise, or you're going to need to give them a lot of notice that the contract, the terms of their employment are about to shift. And this is the point that I was just going for. You can introduce contracts midstream, and it requires that fresh consideration or notice. But again, if you're just starting out, there's no reason to require yourself to do this. You might as well get it done at the start. It's much more simple, and you don't need to provide any other consideration if they're signing an agreement at the very outset of their employment. So there's no reason not to have that done and not to get that in order at the outset. So that's the contract, and I'm happy to go over any questions that you have at the end of the time. So if you have them now, please do type them in, and we'll get to them at the end of the presentation. The next topic I said I was going to get into is policies that you might want to have in place as an employer. And it's not necessarily things that you want to have in place. Some of them are required. So you have to, by law, have policies to address workplace violence. And this is probably the most onerous policy that there is under the law, because not only do you need to have a plan in place to address what happens if it occurs, but you need to have a proactive plan put in place to show how you're reducing the risk of violence occurring in the workplace. Whereas for things like workplace harassment, workplace sexual harassment, they're still required. You need to have these policies, but they're more about having a complaints procedure for something that has happened and having a proper investigation procedure to investigate complaints that come up. So there's no real obligation for the policies to address how those will be, how you'll prevent them. It's more how you'll address them. All of these policies need to be in writing. They can't be anything less formal than that, and they need to be posted in a conspicuous place where every employee would see it. And the workplace violence policy, as I said, there has to be some kind of active process of renewing it, reviewing it, and putting it into place. And the last policy that's required is occupational health and safety. And again, if you have any questions about these specific policies, this is kind of just a high-level primer. But if you want to drill down into those, we can ask questions about them, or we can contact me after the webinar is over. There are a significant amount of other policies which are good to have, but aren't necessarily legally required. These are just, you can consider them an extension of your employment contract, where you're trying to do your best to explain what is expected of employees and explain what rights and obligations that they have at work. So again, we highly recommend having any kind of human rights or anti-discrimination policy. simply because it happens. There are these kinds of incidents in virtually every workplace that's of a significant size, and you need to be prepared, and it's best to think of these things beforehand to have them in order. Social media policies are big ones these days. What can be posted, and it can govern somebody's private life too, like to make sure, because your employees and their posts, if it's obvious that they are employees of your company, it can negatively reflect on your organization. So you want to make that clear that, hey, you do have a right to express yourself in your own free time, but if anything that you say reflects negatively on the company, there will or could be consequences for that. A lot of these policies are about, like I said, setting expectations so that you can point to them if you need to discipline employees, and it's been clearly communicated to them that they're not free, or they're not free from consequence for posting whatever they may say in their own time. And to be able to point to a policy that they have been provided at the outset of their employment, they can't really say that they didn't know that was wrong and that they shouldn't be disciplined as a result. So you're just setting yourself up to be in control of the situation. Different things like information technology and electronic use, so proper use of computers at work. Again, it's a very surprising one, especially with younger workers who, expect that, or they can do whatever they want on a computer that's in front of them as long as they're getting their work done. You want to, if that's okay with you, that's okay. If not, you can say that your use of the internet here is for business purposes only, and it's not meant for personal use, and it will be monitored accordingly. Attendance policies and absenteeism, what someone has to do if they're not going to be into work, when you can require medical information if they will be away for a significant period of time. I did mention vacation and overtime in your employment contract, but some companies like to have more detailed overtime and vacation policies, including, especially for vacation, about when you'll be entitled to more of it, or it can increase as things go on, things that are a bit too detailed to go into in an actual employment contract. A drug and alcohol policy is a big one, especially these days with with marijuana being legalized. It's a hot topic because it's the difference between marijuana and alcohol, obviously, is that marijuana is a medication. So someone may be legally prescribed marijuana to use, but it still may impair their ability to do their job. So you need to have a careful policy, or you may wish to have a careful policy in place to deal with that specific situation. As for drugs and alcohol, illegal drugs, you can just have a zero tolerance policy that if anyone shows up to work under the influence of any intoxicating substance, they'll be subject to discipline up to and including termination for cause. A progressive discipline policy is a good thing to have in place because it shows that you're increasing, it builds your ability to terminate somebody for cause. So I may not have addressed this already, but a termination for cause allows you to terminate somebody without having to provide them any of that notice. So whether it be common law notice or contractual notice in line with the Employment Standards Act's minimums. That's only available to you in specific situations where someone has done something which is a gross breach of the terms and conditions of their employment. It's a high bar, and it's not meant for your garden variety, poor performance, or behavioral issues, or when things are a bad fit, causes for grave breaches or gross negligence or things like that. But if you have a progressive discipline policy in place, it can help you terminate employees for cause in situations that you wouldn't be able to if you didn't have such a policy. So for an example, performance. Again, performance issues, if you're not actively working on them and providing progressive warnings to employees on that basis, you'll have virtually no chance of upholding a termination for cause on performance issues. But if you can show that I have this policy, we've been following this policy, we've been working with this employee to slowly improve their performance or set metrics that we expect them to meet, and they haven't been doing so, you're increasing your chances. And it's just another tool you can use to manage your employees. Some people like to have policies regarding what leaves of absence will be granted to employees. So especially if you're offering things like maternity leave top-ups or stuff like that, those are things that you'll want to address in policies just to communicate to everybody. The Employment Standards Act, as I mentioned, it's implied into your employment relationship, and it sets out a list of absences that you are required as an employer to grant if they're requested. So like I said, things like maternity leave, parental leave, there's leaves if you're caring for sick children or sick dependents of any kind. So the Act specifically lists a variety of leaves that you were required to grant as an employer. If you want to go above and beyond that, which some employers do, handbooks or policies, that's the best place to set those out. So I want to get into the Human Rights Code because it's something that comes up a lot for employers, and it can even come up before you actually have hired anybody. Your obligations as an employer start from the time you're posting a job ad and continues through the interview process and continues through all the way through and after the termination process. So it's something that you need to be aware of at the very outset of, starting your journey as a company. So the main clause in the Human Rights Code is Section 5, where it comes to employment. So every person has a right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. So obviously it covers a lot of different things. It's not, just the basics. This list is always expanding. So it serves you well to be aware of what's protected by the by the Ontario Human Rights Code. The most common thing that I get asked from employers is, okay, one of my employees suffers from a disability. What do I have to do to accommodate them? So that's set out in the in the Ontario Human Rights Code. The code provides a duty on employers that they have to accommodate employees with disabilities up to the point of undue hardship. So undue hardship is not exactly the clearest standard that the law knows. It's very gray and it's very fact specific. So it's not just, this is too hard for me as an employer to do, or too time consuming, or too expensive even. You need to show a high level of prejudice in order to get out from a duty to accommodate. So if it's something as simple as changing someone's schedule or allowing them more break times or things like that, the Human Rights Tribunal, which adjudicates alleged breaches of the code, will expect employers to take those steps and any steps up to this point of undue hardship. And the most common issues involving the code relate to disabilities and relate to injured workers. So workers who are injured, regardless of how that injury happens, whether it's at work or away from work, and they require a period of leave, they are protected by the code for that period of leave. And the return to work process is also governed by the code, and your duty to accommodate is active there. So typically how this works is when the employee is ready to return, they will provide a doctor's note, which indicates that they're ready to come back, and here are the specific restrictions that they may be subject to while they're coming back. If the note isn't specific enough, you can certainly obtain more detailed medical information so that you as an employer know exactly what you can and can't have this employee doing when they come back to work. So it's meant to be a collaborative process between yourself as an employer, your employee, and a medical practitioner. And it's a tricky process because, oftentimes you'll get a note from a doctor which is too vague and you need to go back and obtain more information from them, or they'll be suggesting restrictions which are extremely different from the role that they were doing before they were injured. And a lot of times employers may just throw up their hands and say, we can't accommodate this, it's too different, and so we're just going to have to let you go. Again, I don't think that comes from a malicious place, and I don't think it comes from a discriminatory place, but that theoretically in most situations that's going to be a breach of the Human Rights Code. And so there are general damages and various types of damages that attach to a finding that an employer has breached the code. So the first thing that all employees who are claiming under the Human Rights Code are general damages for discrimination, for violation of their feelings of dignity and self-worth. Those can be pretty significant. In more serious cases and blatant cases of discrimination, it can be upwards of $40,000 in general damages. Most cases are more commonly between 10 and 20, but for significant breaches, they can be high. If a tribunal finds that that person was terminated for a reason that related to a disability or for any discriminatory fashion, they also have a pretty extraordinary power to reinstate the employee to the position that they held. So they can order you to take the employee back and pay them whatever wages they would have earned between the date of their claim and the date that their reinstatement is ordered. And the Human Rights Tribunal, like a lot of other courts, does not move quickly. So you may be waiting a year, 18 months before you actually get to a hearing. So you could get all the way to the hearing, lose, and then be ordered to pay a year and a half of pay to this person and take them back. And you essentially receive nothing in exchange for that 18 months of salary. And you now have to shoehorn this person back into your operations. The smaller the company is, the more difficult that can be. So it's all the more reason to try to do it the right way at the start. And again, it's something that it takes time as an employer to understand what your obligations are there. And as I'll get to later, really the best instinct you can have is anytime you're dealing in a situation like that is to reach out and ask for legal help, and we'll help you walk through the problem. So yeah, here's what I was getting into, the top reasons to contact a lawyer. So the first, and I think we've dealt with this in some of our other webinars already, is just basics for getting started. So things like incorporation, whether or not you want some kind of partnership, cost sharing agreement, or shareholder agreement, or anything like that. Again, as I went through today, employment agreements, workplace policies, they're great to have right from the outset because you're getting yourself organized. And I know it can be difficult because when you're first starting out, your focus might be elsewhere, right? You're trying to nail down your business and to get things up and running from a commercial perspective to make it viable. You're not looking to spend money on things like, that may save you money in the future. But it's incredibly important. I can't stress enough how it really only takes one bad experience terminating an employee to make you see how valuable those are for you. And for the policies, I mean, as I went over, they're mandatory to some extent. So if you are spot audited by the Ministry of Labor, which can happen, and you don't have these policies in place, they aren't too hard about it, but there can be fines that are involved in that. So, and other things you'll need when getting started are things like commercial leases, which we can help you out with here, and wills, which is something that's not obvious immediately, but you're taking on all these new assets and liabilities with your corporation. Corporations can have wills of their own meant to essentially set out what happens upon death. The second obvious time to contact a lawyer is when you actually want to terminate an employee. So, and that happens before you terminate the employee, ideally. I much prefer getting calls from clients before something has happened, rather than them calling me and saying, I did this, was this okay? Sometimes it is, but it's best to get out in front of this and coordinate a plan with your lawyer as to what you may owe this person upon termination, how to actually conduct the termination meeting, because you can incur additional liability if it's conducted in an unduly insensitive fashion. So we can walk you through exactly how to conduct it, what to say during it, the fact that you should probably have more than just one person communicating the decision, so that in case there's an allegation that something was said in the meeting, that you have two people to the one person on the other side. And we can help you set out the post-termination obligations you have. So delivering a statement of wages to the employee, which is something that you have to do, and issuing a record of employment, which is something that you need to do as well. Another common one, increasingly common one, is when you receive a complaint of harassment or violence that occurred in your workplace and you need to investigate it. So these are things that are difficult to do, especially in smaller workplaces where everybody works closely together. You need to discuss with a lawyer the nature of any allegations made and then tailor an investigation that's appropriate. So if the allegations against the supervisor, obviously the supervisor can't have anything to do with investigating the complaint. It has to be somebody completely impartial. They have to ensure that it's, to the extent possible, anything said during the investigation is confidential. We need to discuss during the process what the findings of the investigation are and what discipline or what steps you need to take in order to rectify what has happened if there's a finding that there was harassment or violence. It's steps to avoid that going wrong in the future, because you can incur liability as an employer if you were aware of a situation, didn't address it, and then that same situation represents itself again. And another key thing is not to reprise against any employee for vindicating their rights to make complaints for harassment, make complaints of violence, or to exercise any right that they may have under the Human Rights Code or the Employment Standards Act. If they're exercising legal rights that they have, they can't be punished or threatened in any fashion by an employer. And again, I know it can happen. I know it sounds like at this point you're thinking, okay, well, what kind of terrible person would do something like that? And I'm never going to do anything like that. But it's not as black and white as it seems. In a lot of situations, you'll get claims from employees who maybe made a complaint for harassment years ago, and you terminate them 2 years later, and they say, well, ever since I made that complaint, things just kept going downhill, and I feel like my termination was related to that reprisal, so I'm suing for additional amounts. So that's again, going back to the last point, important to address these things with your lawyer before you conduct the termination, just so a proper assessment of risk can be done. Anytime you're served with any documents, you receive legal documents, it's a good time to call a lawyer. You might get them from, on the employment side, they might be Ontario Labour Relations Board documents, Ministry of Labour documents. So that's if employees are alleging that they were underpaid or there's something wrong with your employment practices. Human Rights Tribunal or Superior Court, which is the standard lawsuit. That's where you're bringing lawsuits. All of these tribunals have different times where you need to respond to applications by, so you want to get them into the hands of a lawyer as soon as you possibly can, because if you sit on it for a week or so, a deadline may have already passed, or you've at least limited the amount of time that you have to respond to it properly. So the sooner that we get it, the earlier that we can assess all the facts and then prepare and coordinate a response that's as detailed as we can possibly be within the time frame. Leave requests, again, you'll get these as employers. People want to take leaves for various reasons. Some of them you're required to give under the Employment Standards Act. You're required to offer, like I said, things like parental leave, maternity leave, and there's guarantees provided that these people will have the same job upon their return. And those are held sacred, and they're there's very few workarounds to those things. if you're closing down shop, you obviously can terminate people who are away on a protective leave because you're treating everybody the same in that situation. But short of that, it's pretty difficult to single out somebody who's on a protective leave and terminate them. But when you're receiving the leave requests, some of them are protected by the ESA, some aren't, right? Someone may want to go back to school or something like that. You can offer that leave, you can grant it if you want, but that's not something that's protected under the Employment Standards Act or protected under the Human Rights Code. So that's a judgment call, but it's important for you to know what's a judgment call and what's an obligation that you have under the law to avoid incurring any liability. So an important thing to know is that there's leaves that are provided for under the ESA, but anytime someone's requesting a leave, they're also exercising rights that they have under the Human Rights Code. So just because someone may have the ESA sets specific timeframes for how long a specific kind of leave can be, but if someone needs more leave because something has gone wrong that relates to a disability or some other aspect covered by the code, then you still have an obligation to respect that leave. It's not as if you can say, well, you've taken longer to come back than is required by the ESA, so we're not holding your position anymore. Again, you're not violating the ESA there, but you may be violating the Human Rights Code. Again, another good time to call a lawyer when you're hiring new people, just to ensure that your employment agreements, if they've already been drafted, are in good shape. It's best not to just blindly use previous template agreements that you got from a lawyer. There may have been changes in the law, or it may not be appropriate for the new employee. A common example is things like non-solicitation and non-competition clauses. They may be appropriate to have in agreements for senior level, management, face of the company kind of people, but they're not appropriate to have for your entry level people. So they need to be tailored even if you are working with templates. Again, as I mentioned previously, there are human rights violations you can commit during the hiring process. A big one is listing, that the person must be a Canadian citizen or permanent resident in order to be considered for the position. That's problematic. A lot of people do it just as an instinct. They don't really, they've seen it in other postings and they just list that because they think that's true or that's something they can do. It's a recipe for disaster. As long as someone is legally entitled to work in Canada as per any kind of work permit, then your obligation is to consider them on an even playing field with anyone who may be a citizen or permanent resident. Other things like your duty to accommodate disabilities extends through the hiring process. So if someone needs help getting to an interview, you'll be required to help them out to do that. So a theme that you'll get, and if you interact with a lawyer, is the Human Rights Code and the Employment Standards Act are quite onerous on employers. There's a lot of liability that you're incurring as an employer, and a lot of times you'll think to yourself that this isn't fair and how can anyone possibly comply with this? And I sympathize with you. I do. But they do exist and it is in place. So our job is to try to navigate some tricky situations to the best that we possibly can. Another thing in the hiring process to avoid is certain kinds of questions. And we can talk about what questions those are, but you're not going to want to be asking things like, what are your plans for having children or anything like that, or anything relating to past medical history that's completely irrelevant to the position. You're just asking for a human rights complaint if you don't end up hiring these people, because they can then make the pitch that I would have got this job but for the fact that I said that I was planning to have children in the next 2 years. And then you're on the back foot defending a human rights claim that was completely avoidable. Again, I touched on this before, but anytime you want to make changes to an existing employment agreement, depending on how big the change might be, you'll probably want to consult with a lawyer to see whether or not you can do this or whether or not you're getting into the risk of constructive dismissal. And if you are making a big change, then as we discussed before, fresh consideration or some kind of notice for material changes. And those are the topics that I had prepared, but I'm happy to take any questions that have flowed in throughout the process. I don't know what time it is, but.
Thank you very much for that, Brent. A very helpful overview. And yeah, you're quite right. A whole lot of things for employers to have to be aware of, particularly any new employer who's trying to get to grips with how they grow their business. We'll give everyone a minute or two to type in some questions. And just a reminder that you can download copies of the slides from the control panel and use the control panel to send in any questions you might have for us as well. And if you have any problems with that download, just drop me an email and we'll follow up with an email back with a copy of the slides. And also give a plug for our next webinar on our series for small and growing businesses, which is happening on February 4th, which will all be about preventing and managing litigation. And as employers and in growing businesses, the bigger you get, the greater the chance of either an employment dispute or commercial dispute arising at some point. So we'll be running through tips for how to ideally avoid those things happening in the first place. Brent, so many potential questions, and one that intrigued me was the fact that all these obligations start in the recruitment process. You mentioned one thing for the ads about not putting in, it must be a Canadian citizen. Presumably you can't put in young, energetic go-getter.
Yeah, so there are specific, you want to avoid anything relating to any of those grounds that I mentioned. There are very narrow exceptions where you are allowed to state your preferences for certain kinds of candidates, but you have to be a certain kind of business or organization to avail yourself from them. So if you're, a church or something like that, and you want your employees to also be the same denomination of that church, there's narrow exceptions for those situations, but not for your run-of-the-mill employers. And you'll want to make sure that you're not wording your adverts in any way to discourage or encourage certain aspects, certain types of people, certain classes, I guess, of people to apply over others.
And when you get those applications in, are there do's and don'ts of perhaps creeping somebody on Facebook and learning a bit about working that way?
No, I don't think that's you're entitled to do due diligence, and as long as you're only using publicly available sources, I don't see any particular problem with that. Now, if someone could prove that you went to someone's Facebook and saw that they were pregnant, and that person then didn't get a job offer from you, theoretically that's a violation of the Human Rights Code. So again, being aware of what is and isn't a violation is an important part. And just as something that to back up, it's not that you have to fire someone because they were pregnant, for example, to incur liability under the Human Rights Code. As long as that pregnancy was a factor in your decision making surrounding that employee, if it was just one of the straws on the camel's back, then that's enough to trigger liability under the Human Rights Code.
Okay. One thing you often hear growing businesses say, well, we're bootstrapping here, let's get some interns in.
Right.
Are there guidance that, is it different when you have an intern versus an employee? Is there a bit of a gray area there?
Yeah, I mean, there's something you need to be really careful with, because interns and employees, there's really no distinction. If someone is doing work for you, there's very narrow exceptions as to when that work cannot be paid. So again, if you need to go over with a lawyer exactly what you're going to be getting these people to do for you, and to make sure you're not violating any labor laws by not paying them to do that work. So yeah, that's an interesting one.
Okay. Another question in here. Do employees have a time limit to file the complaint regarding constructive dismissal after termination?
Yeah, so that's subject to the same limitation period as anything else. So it's 2 years from the date of when they resigned their employment because of this change. An interesting situation happens when you change someone's work and they accept it and continue working, but then sometime later may say that, oh, I feel as though this change is significant and I've been constructively dismissed. The deadline between those two times, there's no firm fixed deadline in the cases, but effectively the longer somebody waits to raise a complaint about a change, the less likely it is that it's going to be found to be constructive dismissal. So if someone is essentially acquiesced to a change and they've grown to live with it, they're prevented from then arguing that that change was so significant.
And one last question for you, Brent. You mentioned at the outset the contract should specify overtime provisions. Is there, but the ESA also specifies what those are. Is there flexibility in that, or is it always what's set out in the ESA?
Yeah, so it's set out in the ESA. There's no ability. So you can theoretically, if you want, set an earlier overtime threshold. So in the ESA, it's 44 hours. Anything above 44 hours, you're paying time and a half. If you want, some employers I know, if they've got a 35-hour work week, they'll say anything over 35 hours, you're earning overtime on that time. The key is that if you're providing a greater benefit in your contract, that's always going to be fine. But if you're trying to push it to, okay, well, we don't owe you overtime until 50 hours, that's not going to be okay. So there's flexibility if you're offering more. There's no flexibility if you plan to offer less. There is ability to determine how overtime is paid out. So it can be paid out if the employee agrees through time off rather than pay. And if that's something that you prefer rather than paying out money for overtime, should be addressed in a contract because employees have to consent to that arrangement.
And one last related question, overtime and statutory holidays, if employees are required to work, is that described?
Yeah, it's in the ESA. Off memory, I think how it works is if someone's required to work a stat holiday, you're required to give them an alternate day off in place of that stat holiday. It's not necessarily that you're automatically getting time and a half. It's just that you need to replicate that stat holiday elsewhere.
Great. Well, we've come just a little bit over our allotted time, so we will sign off now. Brent, thank you very much for that overview.
Thanks, Keith.
I know it's complicated for everybody who's trying to do this, so I know if you do have further questions, I'm sure Brent would be happy to take your call or email. His details are on the slide, and hopefully we can see you again for the next webinar in February. Recordings of the previous ones are available through the Kelly Santini website. We've had a couple of requests in for copies of the slides. So if you did have difficulty downloading, not to worry, we'll follow up later today with a copy of those slides. And I guess that's it.
Okay.
So thank you very much for spending your lunch hour with us.
Yeah, thank you, everyone.
We enjoy the rest of the day. Thanks.
Take care.
Bye-bye.